We disagree with the judgment vehemently.
Completely.
Yes. Yes.
And we are going to fight it from here onwards until justice is done.
Yes. Yes. Yes.
There's no justice yet. Yes. Suspect the judgment is not based on law. It's not based on facts. It's based on politics. It's based on some tribal, primordial sentiments. Just because Nnamdi Kanu is Igbo. An Igbo man has become the person in Nigeria that should be trampled upon. I'm not saying this because I'm Igbo. I'll say it for the Hausa or Yoruba who gets trampled upon. But today we saw an Igbo man being trampled upon, and by God Almighty, we are not going to allow it.
Yes.
That was the Court of Appeal. But then the more important thing we need to consider is that decision by the Court of Appeal extinguished totally, completely, absolutely, and brought to permanent closure the retinue of charges Nnamdi Kanu was facing up to that point. It extinguished everything, that ruling. So if the federal government wanted to continue with the trial of Nnamdi Kanu, it needed to have started on a clean plate after December 15, 2023, when the Supreme Court upturned the judgment of the Court of Appeal. Do you understand?
Yes.
But they didn't do that. They went back, they pedaled back to bring back charges that were practically dead, and charges that were also brought under a dead law, and charges that were completely extinguished by dint of the discharge that occurred at the Court of Appeal. So, despite the fact that the Supreme Court judgment varied or upturned that judgment, it upturned it on one ground only, on the ground that rendition did not bar the Federal High Court from proceeding with trying anybody in Nigeria. But it didn't say expressly or specifically that those charges that were standing against Nnamdi Kanu be brought back, or the charges be brought back under a law that was repealed in as far back as July 2022. So the decision of the Supreme Court came more than a year later, in December 2023. And then you take Nnamdi Kanu back to court based on a law that had long been repealed.
Now, that is where I also need education.
Okay.
Consistently, I've been following it.
Yes.
Nnamdi Kanu has insisted that if there is a law in our statute books warranting his prosecution, based on which he could be charged, that he will face trial.
Yes.
But there's no law to that effect.
Yes.
Can you kindly educate us?
Well, I would. If you recall, in Joko, during the military administration, we used to have the Armed Robbery and Firearms Tribunals.
Correct.
We also had the Armed Robbery and Firearms Decree.
Yes, we did.
Now, the punishment or the process for bringing armed robbers and people who allegedly possessed firearms illegally, the process then during the military administration was very arbitrary and very summary, and the process was taken outside of our black letter traditional law to come within the purview of a military decree that did not guarantee minimum fairness. You could be tried in under 2 weeks or 3 weeks and be executed. The same thing for those who were accused of running drugs or narcotics.
Yes.
Now, as soon as the military administration sunset and we return to civilian administration, that law also sunset and the law was repealed. So everybody who was standing trial for armed robbery, drug offenses, firearms offenses were brought back into the traditional law, what we have as Criminal Code Act or Criminal Procedure Code. So nobody was facing firing squad anymore. Nobody was facing arbitrary and summary trial anymore. So you even though you were accused of something, you were given the benefit of taking advantage of the new law in place. So nobody was going to pedal back to military era repealed decree to put you under the pain of summary trial within 2 to 3 weeks before a panel not comprised of lawyers but military officers, and then you are taken to your village and executed. There's no more death by firing squad here, but we used to have it. So I think this is the best analogy. There was a terrorism and a law called the Terrorism Prevention Amendment Act 2023. The charges Nnamdi Kanu was facing until he got discharged by the Court of Appeal in 2022, these charges were initiated under that act. Now, I had explained previously that while these things were going on, the act got repealed. So it became a dead law. So now, when the Supreme Court said, well, there is something you need to explain to the High Court. You need to stand trial. We know you are rendition. That was wrong. But you need to stand trial. It didn't say you need to stand trial under a repealed law. It would be akin to say you need to stand trial if you are alleged to be an armed robber under the Armed Robbery and Firearm Decree that has been repealed. If a court subsequently says you need to stand trial, it means you need to stand trial under the Criminal Code or the Penal Code, and the procedure that shall apply will be the Criminal Procedure Code. Just like we had in 2015 with the promulgation of the Administration of Criminal Justice Act 2015, all the Criminal Code Procedure Code, all the criminal code procedures in place in much of Nigeria got extinguished. So everything that was pending at that time was brought under the purview of the new law. This was the kernel of Nnamdi Kanu's argument that it is jurisdictionally questionable, maybe even a nullity, and it defeats his fundamental rights to fair hearing for him to face trial under a law that has been extinguished. And guess what? That law that was extinguished wasn't extinguished for no reason. The law that replaced it, the Terrorism Prevention and Prohibition Act 2022, was meant to bring Nigeria in conformity with the international best practices in the global counter-insurgency, counter-terrorism effort. For instance, the old law carried the death penalty, but the world community came together and said, well, it's probably too harsh. Let's go as long as life imprisonment. They removed the death penalty. And under the new law, most of the offenses he was charged with carried maximum number of 20 years to run concurrently. Now, under Section 76 sub 1D3 of the new law, if the terrorist act or if the overt act leading to the alleged incitement of terrorism occurred outside Nigeria, the Federal High Court of Nigeria does not have jurisdiction unless it can be shown by the government that that very act also constituted a terrorist offense in the country where it occurred. Now, on the charge sheet, the allegations made inside of these 6 counts of the charges, 7 counts, 6 out of them carried allegations of broadcasts made overseas between 2018 and 2021 when Nnamdi Kanu was not here. They are the ones that indicated that window of 2018 to 2021. So if you made that indication that basically said that you, Nnamdi Kanu, made a broadcast and you didn't mention the location of the broadcast, you made a broadcast that led to incitement of terrorism or commission of act of terrorism in Nigeria, you need to also mention the location
where it was made,
so that in our proceedings in the court,
it can be then established whether in that country,
to be strict proof, whether the broadcast, say for instance, if made in Kenya, whether that level or that nature of the broadcast is also a crime in Kenya. If you said he made it in Britain from British soil, is it a crime in Britain to make such a broadcast? If the answer is yes, then the Federal High Court has jurisdiction, and it's called extraterritorial jurisdiction. If it's not crime at the location where the broadcast was made, then it's not a crime.
Now, I pardon me to interject, because Nnamdi Kanu also was insisting on the factor of the court not having jurisdiction. Was it based on this?
Yes, that's one of them. There are several other grounds. For instance, if I begin to rule out the grounds, maybe two minutes. But wait a minute. What we are talking about here is now the Supreme Court judgment that related this case back to trial did not do a whole-scale remittal and closed the window for Nnamdi Kanu to advance his defenses or preliminary objections. He said it at between page 47 and 58 of the judgment that the defendant is entitled to his defenses before the High Court or to advance any objections. And one of them was an objection based on section 220 of the Administration of Criminal Justice Act, which again brings us to the absence of the location of the offense. Non-lawyers may be wondering why location is important. Location of an offense is always important because that is what grounds jurisdiction. So when you don't indicate location where the offense occurred, say for instance, something happened in Sokoto, and it comes within the local judicial purview of Sokoto courts. When you miss that location or the situs, you
will deny that court of that.
Yes, it brings into question the jurisdiction of the next court you take it to in Kaduna. So if you say somebody did something and there is this suspicion that it happened in Sokoto and you are not disclosing it, you begin to wonder why the prosecutor is interested in Kaduna or trying a case in Kaduna or trying an offense that allegedly occurred in Sokoto. So it's a judicial question that challenges the territorial jurisdiction of the Federal High Court here. Do you understand?
I do.
So, and sometimes lawyers call it the rule of double criminality. And again, under the Administration of Criminal Justice Act, you are not permitted as a government to confuse the accused or the suspect with the way he drafted the charges against him. You have to be explicit, clear, avoid ambiguities and vagueness and overbroadness, so that the accused will be well informed of what he has done. That also will enable him to effectively defend himself. Any of those missing informations which misleads the accused brings into question the authority of the court to proceed with that trial. And the absence of the situs, location of that offense, confused Nnamdi Kanu here. So how do you defend something that you don't know where it occurred?
Now, we followed the proceedings all throughout yesterday.
Yeah.
There are two things I also again want you to educate us on. We have not come to what next, but let us be educated before we ask you what next.
Okay.
His Lordship said that the sentences were run concurrently. But there was one 5 years, one 20 years, one life imprisonment. What is to run concurrently?
Well, if you run concurrently, you are looking at about 20 years.
About 20 years.
Life imprisonment is about 20 years with good behavior. It could be more with bad behavior and all that, but you need to sit down and crunch the mathematics and get the exactitude, the exact number of years. But you are looking at minimum of 20.
It was minimum of 20, and this trial began. Nnamdi Kanu has been in the custody of the government since 2021. This is 2025.
He's going to get credit for that.
He's going to get credit.
And for the 18 months he spent between 2015 and 2017.
If that.
So he'll get credit of about 6 years.
About 6 years.
Yes.
Thank you for the education. Now, I will also watched the prosecution counsel stridently tell his lordship that Nnamdi Kanu should be sentenced to death.
Yeah.
That is the job of a lawyer, maybe. But in this conversation, you said that death sentence is not part of the new law accepted internationally.
Exactly.
How did this death sentence come up?
How?
Yes, why should it come up? Because his lordship already knows if he's applying the current law.
Does the lordship really know? I mean, he might have known, but the court evidently closed its mind.
Okay, in other words, this trial then did not go on based on the current law, but on the extinguished law.
That was our main contention. That was the main contention of Nnamdi Kanu, that this trial be conducted under the current law. I mean, is it asking for too much? Why are they pivoting on the old law? Because they wanted to get the death sentence.
Now you're a lawyer.
It was very clear.
Please, you're a lawyer. You're going to appeal. I say you're going to appeal. We're going to discuss that currently. Yes. But does it make legal common sense that a law no longer exists? A new law is in the statute books operating, and the process decides to go back yesterday to try a case of today? Does it make sense?
It doesn't. Anyway, let me break it down. Some new laws do carry what we call savings clauses, and under Section 6 of the Interpretation Act, the repeal of a law does not necessarily mean it is totally extinguished or its application has sunset totally.
Even when there's a new law replacing.
Exactly, because that new law may contain a savings clause. This very new law, the Terrorism, Prevention and Prohibition Act that was enacted in 2022, carried a savings clause under Section 98 that saved acts performed under the old law. Completed acts are acts that were still ongoing. But Nnamdi Kanu's case was no longer ongoing as of October 13, 2022. That was when his case ended by discharge. Discharge of a suspect or a defendant ends his case. If you're discharged today, Njoko, you may be lucky enough, if no bureaucracy occurs, you go home from the court house. You don't go back to jail. I mean, you might go back to jail to pack your things, but you might wax proud and say, "What am I packing my things? I will send one of my boys to pack my things." You go home from the court. When Nnamdi Kanu was discharged on October 13, 2022, they took him back to jail. They never released him. They never obeyed the order. Equity requires you to have clean hands. This is a man that was discharged. You held him tight until you appealed, and then you went and got a stay of execution of the discharge judgment within 2 weeks, or let me say within 13 days. On 26th, you got the thing to be stayed, the judgment to be stayed, and you held him in detention since then. And this is despite other rulings of courts around the country and the international community. So the federal government never had clean hands in this prosecution. That's my concern. My primary concern really was the federal government, not the court, because the courts lack the jurisdiction to initiate criminal trials except when you commit contempt in the face of the court. But the government, the executive branch, the presidency, the attorney general have to take a case before the court before. So the aggressive prosecutorial policy towards Nnamdi Kanu was very baffling to me, and I was questioning why. And guess what? I found out why. It is tough being an Igbo man in Nigeria. It's tough for me. Being Igbo in Nigeria is very tough for me. I know what I passed through. I know the opportunities I have lost. So when it comes, I didn't know that this thing could be extrapolated to criminal prosecutions. It was very vicious. The prosecutorial policy levied against Nnamdi Kanu was very vicious, and you had to ask yourself why. Just because of mere broadcasts made from a foreign soil. Are you trying to tell us that if the witch cried at night and the baby died in the morning, it's the witch that killed the baby? He made a broadcast, and certain acts of violence was committed, or acts that you term terrorism was committed in the southeast, and you're linking the two. I don't believe there's any nexus, because nobody who committed such acts, you have thousands of alleged IPOB members, alleged ESN members in your detention facilities across Nigeria, including the notorious Wawa barracks in Niger State, where they are tortured, and Tiger Base in Owerri. And none of them, since 2015, has pointed a finger. Nnamdi Kanu, despite confessions he obtained under torture. Nobody has said, I attacked a policeman, I attacked anything, I shot somebody because of Nnamdi Kanu's broadcast. There was no single witness brought to say that. There was no single documentary evidence indicating that. And then you left that aside and you pivoted to NSAS. And you now convicted Nnamdi Kanu for his remarks. Even though some people said incendiary, a lot of people made incendiary remarks during NSAS. Uloshoyinka supported NSAS. Foreigners supported it. Twitter founder Dozie supported it, and they created a very viral hashtag for it. And nobody has ever been convicted of NSAS protest except Nnamdi Kanu. So you begin to ask yourself why. The answer is as obvious as it can be. It's a stuff, being an Igbo man in Nigeria, and this is what is fueling the agitation that is at the bedrock of all these things. And you think by jailing him, you know, it's a magic bullet that will solve all these problems? No, I think he's going to create more discontent. I hope that people will remain calm and not resort to self-help. But when a segment of your citizens, a very big segment as Igbos are, some people put our population between 50 and 70 million, if you count those in the diaspora, they are not happy with you. Your alpha males are not happy with you as a country. You talk with them. You don't seek to jail them, or you don't seek to subdue them through the instrumentality of, you know, putting the poster boy for their yearnings and aspirations and angst and discontent in jail for life. It will be tantamount to jailing the entire tribe. So I think the federal government needs to, retool itself, go into a rethinking mood and ask itself some political questions. Not legal. This matter has never been legal. If any, the legal aspect of it was very scintilla, very small. Much of it has quantum political content. So the federal government needs to double back and say, hey, what are we doing here? Maybe this conviction has opened a new opportunity for a political solution.
We'll come to that present.
Yes.
But let us go.